The trial for two of the officers charged in the death of Elijah McClain picks back up today. And this morning, we want to dive into the people selected for the jury.
Yeah, our 9 News legal analyst Whitney Traylor joins us now. Whitney, let's start with how this jury came to be in the first place.
Well, it's the voir dire process. So this is like every trial, every jury trial. In Colorado, you're going to have between 6 and 12 jurors. And so you start off with a pretty massive jury pool, and then you whittle it down, and then the lawyers get to examine them, and eventually you end up with a jury of 12. Here they started with, I think, over 250 people. And the issue here was because this had gotten so much media attention and it dealt with law enforcement, it was the question to the jurors were, can you be unbiased? And some people had law enforcement in their family and they said, yes, I can be unbiased. Other people said, no, I've seen police brutality, family has experienced it, I can't be unbiased. And so it's that process so that they hopefully ultimately come up with a jury of unbiased folks, which they ultimately did.
There was this conversation this week about a potential mistrial. And this all comes down to, I mean, you talk about 250 people, right? The process that it takes to come down to a jury, right? Here they have a jury, then there's a death in the family for one juror. There's other issues. We were talking about one of the jurors falling asleep during this, sometimes in very pivotal moments. So what are the rules for the jurors?
Right. Well, so there are rules. There's juror conduct, and this is really determined by the judge. And the judge gives jury instructions before every trial, and tells them what they can and can't do. In some instances, the jury will be sequestered, where they'll have to, sit aside. And it's interesting. People will say, how could a juror fall asleep in such an important case? But I'll tell you, if you've not sat on a jury, and I encourage everybody to do so if they get the opportunity. I know everybody wants to get off of a jury, but when you're listening to hours and hours of technical testimony about asphyxiation and these very complex ideas, and you're sitting there listening all day, it's a very passive process until you get to actually deliberate. It can be difficult to stay awake, maintain your focus, and that really focuses on the lawyer and the lawyer's ability to not entertain, but to keep the jury, know when a break is needed, know when some extra energy is needed, etc.
Yeah, and you're not kidding. They get into the nitty-gritty details. I've sat through those long trials before from the journalistic side of things, much less the juror side of things. The question, though, is if somebody is falling asleep, is that kind of behavior that might warrant a mistrial?
Probably not, because, and there is juror misconduct, and juror misconduct could be things like a juror going home and doing research on the case, talking to other people about the case, reading media, and this is where the judge says, hey folks, don't do these things. So someone falling asleep, I don't know if they fell asleep throughout. I mean, we're only on day 3. This trial is going to go on for a long time. So at some point, yes, that could be the case. Now here, as Corey and I were talking about the other day, there's 12 jurors, as I understand it, and then 2 alternates. And the reason is in case somebody falls off, they get sick or pass away or can't continue, you have these alternates in place. But you only need 6 jurors. Constitutionally, you could make a decision with only 6.
So I think that's what's so interesting is if we had one juror excused because of the death in the family, we've got this other juror who's fallen asleep. It's like you've kind of burned through 2 potential alternates already.
Yeah, but again, this is, I mean, I've had lots of trials. I've had trials where the judge just impaneled 6 and 1 alternate. So this is actually a lot to have 12 with the 2 alternates. And it's interesting, especially if folks haven't served on the jury, the alternates don't know they're alternates. And it makes sense because they might not pay as much attention. So they pay attention through the weeks of testimony, and then when it comes time to deliberate, the judge will say, hey, you two, you were alternates, you're excused. And it's kind of, it's not a great process, but it's there designed that in case people fall off, we have these alternates.
Well, Whitney, we appreciate you helping us understand a little bit more about the process.